Okay. So good afternoon, class. So let us start again with business law. So what are we doing? Which unit? What is the chapter name? 22. Okay. And in that, what did we discuss in the last class? Essentials of a valid contract. In essentials of a valid contract, we have seen two parts. What are the two parts that we have seen? Given under section 10, not given under section 10. So what are the essential elements which are not given under section 10? Slowly and should be, yes, one at a time, one at a time. Intention to create legal obligation, not given under possibility of performance, yes. hmm? Certainty of meaning, other formalities to be complied with. So these are the five essential elements given, not given under section 10. Now given under section 10, offer and acceptance, free consent, capacity to contract, lawful consideration and object, not expressly declared void. So these are the 10 essential elements which make an agreement a contract. Because if these essential elements are present, then only it is enforceable by law. Agreement which is enforceable by law will become a contract. Okay, so we have seen all the essential elements. Then we came to the types of contract. Types of contract we have seen under three bases. The first basis was based on validity or enforceability. So based on validity and enforceability, the contracts are divided into how many types? Valid contracts, void contracts, voidable contracts, illegal and unenforceable contract. Based on formation, it is divided into four types: express contracts, implied contracts, quasi contracts and e contracts. Then performance divided into executed and executory contracts. Under executory you again have unilateral and bilateral. So, based on validity or enforceability, we have seen three types of contracts. We have seen valid contract, we have seen void contracts, and we have also seen voidable contracts. Now, you tell me what is that you mean by a valid contract? Valid contract is a contract where enforceable by law. So, what is present? All essential elements are present in any agreement, then only it is considered to be a valid contract. What is void? Which section? Clause J of section 2. What is the definition? Come on, anyone. Enforceable. ऐसे start होता. Come on. Not enforceable. That is the definition. Enforceable by law becomes void when it ceases to be enforceable by law. Yes or no? The avoidable contracts. Which section? Clause I of section 2. Who will define? Come on, raise your hand. Who will define? You can see and define also. Definition. Come on, fast. The option of other. Contract. Very good. Okay, that is voidable contract. So, did you understand voidable contract properly, perfectly? Okay. Now, let us see the next type of contract under basis of enforceability. So, this is our fourth type of contract. Illegal agreements. Or you can say, I'll tell you why I told agreements. Illegal agreements. Now, the term itself is telling you what is that you mean by illegal. Very good. Something which is against law. Something which is going against law. So, illegal agreements, illegal contracts are those type of contracts which are considered to be always forbidden by law. Considered to be always forbidden by law. The word forbidden here means prohibited. Law is saying you cannot do it. Okay, law is stopping you to do it. Prohibited by law. Any contract which is forbidden, any agreement, any contract forbidden by law becomes illegal. Why? Because it is always considered to be what? It is against law. Law is telling you cannot do this. Then also you are doing it. Are you going against law then? Yes, you are going against law. Therefore, it is not considered to be valid. It is always considered to be going against law. Therefore, illegal. You are entering into contract. Say A is entering into contract with B. A is telling B, I will pay you 50% of my profits. 50% I will give it to you only if you smuggle goods for me. What do you do? Maybe B is a custom officer, or he is some excise officer or some government officer who is having the authority, who can smuggle goods. Okay, they are the people who take care of the goods coming from outside, whether it is allowed, it is not allowed. He knows that it is not allowed, then also it is he is allowing it. Why? Because A is telling that I will pay you how much? 50% of my profits I will pay you. You smuggle goods for me. This type of contracts are considered to be always what? Illegal. Smuggling of goods is something which is forbidden by law, prohibited by law. You are going against law, therefore it is considered to be illegal. Illegal contracts are always considered to be void ab initio. It is always considered to be what? Void ab initio, void from the very beginning. See here, illegal, it is not contact, it is contract. Please correct that. Contract. Insert an R there. So here illegal contracts are given, but what did I write there? Illegal agreement. Who can now tell me why did I write? Any one person, you can raise your hand and tell me why did I write agreement there? Yes. Yes, not enforceable by law, not becoming contract itself. Void ab initio means what? Void from the very beginning. It was an agreement, it is an agreement. It did not become a contract only. From the very beginning, it was void, not valid, illegal. That is the reason I just wrote what? Illegal agreements. For you to understand, it can be illegal contract, illegal agreement, one and the same. Why? Because that is an agreement which never became a contract only. Void ab initio it is. Understood? Yes or no? Okay. So always illegal agreements are considered to be void ab initio. Void from the very beginning itself. From the very beginning it is void. Understood with this? Yes or no? Now I'll explain you one more topic under this. Understand carefully. Collateral contracts. Now, what is that you mean by collateral contracts? Collateral contracts are contracts which are for supporting the main contract. Which are for supporting the main contract. Collateral is something which is running along the main contract. Running along means, say this line is the main contract, then this will be running along with, that is the collateral contracts. Okay, now I'll give you one example, the same example which we have seen before. Same example I'm taking here also. A and B entered into a contract. A said B, I will give you 50% of my proceeds. Okay, but what you should do for me? You should smuggle goods for me. What you do? You smuggle goods for me. A is having no authority actually. He is no officer, he is having no authority. But he said, yes, yes, A, I will smuggle goods for you. You pay me how much? 50% of your profits you give me. Now, B is entering into a contract with a person C. B is entering into contract with a person C saying that Why he's entering? He's telling, see, you give me 10 lakh rupees. I, at 10% of interest, I will repay this in 6 months. In how many months I will repay? 6 months. Now, what was the reason why B took a loan of 10 lakhs? The reason was B wanted some money to smuggle the goods. You know, bribery. He wanted to give some bribe to some officer, something. For what purpose did he take this loan of 10 lakh rupees? Only for the purpose of smuggling goods. If there was no contract between A and B for the smuggling of goods, there was no need for B to take any loan. So what is the reason this contract came into existence between B and C? Only because of the contract between A and B. If there was no contract between A and B, was there any requirement for B to take any money? No, he took the money only to smuggle. Otherwise, he did not need any money. He took the money only because he wanted to smuggle the goods. Got this point clear? This type of contract, the contract between B and C, is known as what contract? Collateral contract. And this contract between A and B is what type of contract? It is the main contract. Main contract, if say there is a contract you are entering into, why? Because you need some help for the main contract, you need some support to the main contract. Those type of contracts are only known as what? Collateral. If there is no main contract, there will not be the collateral contract also. For this point clear, everybody? So these are known as collateral contract. Now I'll give you one more example. Understand this carefully. Hmm. No. The contract between A and B is totally separate contract. There is no relation between A and C. They don't know each other. Okay, contract between B and C is take terms, conditions, everything is different, totally different. But what is the main point which is linked between them? Only that the purpose. The purpose that if B and C, the contract between B and C is entered only because B needs some money to smuggle the goods, only to support. Otherwise, there is no link. No link between the parties. Parties are having no link. At this point, clear? So you cannot say that one or more parties are there, then it will be collateral. No. Totally different. For the contract of smuggling, only A and B are parties to the contract, no one else. C is not a party to the contract. For smuggling. For this loan of 10 lakhs, only B and C are parties to a contract. A is having no relationship there. Okay, there are two parties here, there are two parties here. No other parties involved. For this point clear? Yes or no? Okay, I'll give you one more example now. A is an X is entering into a contract with Y, where X is having a house which he wants to sell to Y, and Y is required to pay 20 lakh rupees to X. X is having a house, he wants to sell that house to Y, and Y is required to pay how much? 20 lakh rupees. Okay, now X is saying that Y is a person who needs the house. It is very important that Y wants the house. X is also ready to sell the house. They are ready. Both the parties are agreeing they want to enter into contract, but X is saying that I want that 20 lakh rupees together. No installments. At once I want that 20 lakh rupees. You give me immediately 20 lakh rupees, I will give you the house. But Y is having no money. What he is having? No money. So he is going to a person Z and he is telling, give me a loan of 20 lakh rupees at 10% interest. I will repay after 1 year. You give me 20 lakh rupees, I will repay after 1 year. Now you tell me this 20 lakh rupees was required by Y? Only because he wanted to purchase the house. Without that, is there any requirement of that 20 lakh rupees to Y? No. If there was no contract between X and Y for this house, was there any requirement for Y to enter into contract with Z? Yes or no? So now you tell me which is the main contract here? X and Y house, to purchase the house, that is the main contract. And which is collateral contract here? Y and Z, the loan contract, taking the loan of 20 lakh rupees. Yes or no? Now you tell me, the contract between X and Y, is it valid contract or void contract? Is there any illegality, or is there something which is not? And it is valid, totally valid. Main contract is valid, then this contract will also be valid, obviously. One more example. PQ are two parties. P is selling 100 bottles of liquor to Q. They entered into contract. Q will pay 1 lakh rupees to P. This is the contract that they have entered. Q entered into a contract with S. I don't have any money. Okay, I don't have any money. So I am taking a loan of 1 lakh rupees from you, say at 12% interest. Okay, which I will pay in 3 months. In 3 months, I'll give you the payment. Now what happened? P and Q. P was required to deliver the bottles of liquor to Q in how much days? Say 1 week. 1 week. They entered into contract today, but after a week, what was required to be done? Delivery and payment is to be done when? After 1 week. Contract is entered today, but after 1 week, delivery and payment, that is performance of contract, was to be done after 1 week. After 2 days only, government passed a rule saying that there will not be any trading of liquor in the area. So what did they do? They have banned trading of liquor. Now this is something which was very much valid. When it was formed, it was very, now it has become what? Void. It is only void. It has just become void. For this point clear? So now you tell me, the contract between P and Q is what contract? Main contract, which is void. Contract between Q and S is what contract? Collateral contract. Now you tell me, will this collateral contract will be valid or void? Valid or void? Very good. It should be valid. Why? Because why should S suffer? It is not the fault of S. Actually, it is neither fault of P and Q also. No party is at fault here. They entered into contract thinking that everything is valid, but after they entered into contract, some situation happened, some event happened, because of which it became void. There is no fault of any party here. Therefore, because of the situation, though the contract between P and Q is becoming void, but the contract between Q and S will be very much valid. That means Q will have to pay 1 lakh rupees to Q within 3 months. Immediately also he can pay if he is having money, or within 3 months he can pay. If he is not paying, then what? S can go to court of law and file a case against. Got this point clear? This also, obviously it is valid. Obviously collateral also will be valid. There is no doubt in this. Now we'll come to this point. You tell me this. Main contract is illegal. Not void. It is not void. It is illegal. There is a difference between void and illegal contracts. Illegal. Contract between B and C will be valid or void or what? It will be valid. It will be valid. Law is not saying that. Law is saying that it will be void. Yes, he is. Say, I know you will, what doubt you will get. I will clarify that doubt also. I know that. I know what sort of doubts students get. Okay. See here, what law is saying, you are entering into contract to do something against law. That contract, because of that supporting contract, this contract is supporting you to do something which is illegal, to do something which is against law. So we are not going to support you. When law will not support, when courts will not support, only when it is void. They are not saying that this is also illegal. They are not going to punish here C. Okay, but they are saying that we will not support you. Now you may get a doubt. See, Innocent party. He did not know anything about smuggling. Why should he suffer? Why should he be at loss? Law is saying that you cannot blindly enter into contracts. When you enter into contracts, you have to inquire properly. Inquire. See for what your money is used. Then only you enter into contracts. Blindly, if you enter into contracts, you will be at loss. We will not help you. For this point clear? If I am giving my money to somebody, inquire properly. Who is that person? For what purpose that person is going to use the money? What is the background of that person? Inquire properly. Then you give the money. Okay. Why? Because if you don't inquire properly, why? Because law is saying if you inquire, you will get to know. Now you may get it out. No, he inquired also. Then also he did not get to know. Law is not saying that. Law is saying that properly, if you inquire, you will definitely know the consequences, the background of that person. Okay, you did not inquire, blindly you gave the money. Who will be at fault? You are at fault. So you bear the you suffer, you bear the losses. We are not going to support you. You supported blindly, you supported something which was illegal. Now we are not going to support you. Though you are an innocent person, we are not going to support. Obviously, we are not going to punish you also, but we are not going to support you also. For this point clear? Yes or no? Now understood what is collateral? Did you understand properly? What is collateral contracts? Okay. So what are collateral contracts? Collateral contracts are those contracts which are linked to the main contract, which are going to support the main contract. For supporting the main contract, they are entered. If there is no main contract, they will not be the collateral contract also. So collateral contract to a valid contract is always valid. Collateral contract to a void contract is also always valid. Collateral contract to illegal contract is always void. Clear? Yes or no? So if you want to make a note of examples. Why? Because this is going to be important. हो गया? Done? Done with this? Done? You want to write all these things also, or you're done with this? Everything? Everybody? Okay? Okay. I'll just give you one more example for illegal contracts. A and B entered into contract. A entered into contract with B. I will pay you 10 lakh rupees. You have to kill C for that. What type of contract is this? Illegal. Why? Murdering someone, killing someone is always considered to be something which is illegal. Illegal means always void ab initio. Now these parties, if they are saying, oh, no, nothing void ab initio, what is that void ab initio? It is valid, we will go to court of law. We will go. So what did A do? A gave 10 lakh rupees to B. He already gave. But what did B do? B did not kill C. Now he is saying that I gave you 10 lakh rupees, give my 10 lakh rupees back. Why? Because you did not kill C. Now he is going to court of law and telling that I told this person to kill C, he did not kill C, now he is not paying the money back. What will court do? Court will put A only in jail. You are the person who wanted to commit crime, now you go into jail. Or say, what did A do? A did not give 10 lakh rupees. But what did B do? B already murdered C. B murdered C. Now B is coming to A and telling, come on, give my 10 lakh rupees. C, he is dead. Now A is saying that I am not responsible for anything. I am not going to give you anything. Not 1 rupee also. Nothing I am going to give you. Now B is going to court of law. My lord, see, I have killed C. But A is not paying me 10 lakh rupees. What will be the consequences of this now? B only will have to go to jail. Will law support? No. So clearly, whatever is illegal, you will have no support of law. No parties will have any support of law. The contract is not a contract, it is just an agreement which is not enforceable by law. Clear with this? Now, before going to the next type of contract, I just want you to look into just the differences. Okay. So if we see difference between void and voidable contract, what is the first difference? First difference is nothing but the definition. What is void contract? A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. What is voidable contract? An agreement which is enforceable by law is voidable at the option of one or more parties thereto, but not at the option of others or other, is a voidable contract. Enforceability. Void contract cannot be enforced at all. There's no enforceability. But voidable, can it be enforced? You tell me when it can be enforced. Hmm? Not support. Yes. So generally, when it will be enforceable, only when, see, the option is given to whom? The aggrieved party. This aggrieved party is given what option? Either to say a yes to the contract or no. So when do you think it will be enforceable? When he says a yes. He says yes, yes, I'm okay with the contract. I don't have it. Though there was some pressure on me, but no, I'm okay with the contract. Okay. When he's saying that yes, when he's accepting it without any pressure, without any force, then only it is going to be enforceable. If he's saying a no, then it will become not enforceable and therefore void. So voidable contract can become either valid or it can become void. So what is a voidable contract? Voidable contract is a contract which is having the ability to become void. Voidable, the name itself is telling you. The name itself is telling you what is this voidable? Ability to become void. It is not void. It is not void. When it will have ability to become void? Only when the aggrieved party is saying a no. Aggrieved party is saying, no, no, I don't want to accept this contract. It will become void. Otherwise, if he's saying a yes, it will become valid. Clear? Next. So what is the cause behind a void contract because some event is happening, some circumstance, some situation. When you made that contract, it was very much valid, but after forming the contract, before performing, there is a difference between formation and performance. Formation is what? Entering into contract. Performance is what? Whatever you have decided to do, you're doing in the contract. Whatever you have promised to do, that you're doing in the contract, that is performance. See, performance and formation and performance can happen at the same time also. But there are some cases where there will be a time gap also. You will form the contract now, but it will be performed in future. Say if you buy the tickets, train tickets. Though it is entered, you are paying, but you will be taken to your destination immediately or after some time also. Some time also. So in that also it is a contract, valid contract where performance is in future. So that can also happen. So when there is this time gap of formation and performance, in between some event happens. Between formation and performance, some event happens which is making the contract void. Then it is considered to be always void. When the contract becomes voidable, only when there is no free consent because of four reasons. What are the four reasons? Coercion, undue influence, misrepresentation, fraud. Because of these four reasons, no free consent, the contract becomes always voidable. So this is the cause. Void contract, can it be performed? Do you have to perform the void contract? Obviously not. Nor the contract comes to an end. Immediately it comes to an end. I will not have to do anything for you. You will not have to do anything for me. Both the parties are, what do you say, they don't discharge from performing. They don't have to do anything in the contract because now it has become void. Okay. In case of, now you tell me, voidable contract, will there be any performance by the parties? Exactly, very good. If the aggrieved party is making the contract valid, accepting the contract, you have to perform the contract. If the aggrieved party is not accepting the contract, saying a no, you don't have to perform the contract. Okay. See here also, unlimited time is not given to aggrieved party. Reasonable time. Within reasonable time, you decide whether you want to accept or not. If you're not deciding within reasonable time, it is assumed that you have accepted. That means within reasonable time, you have to go to court of law and file a case. You cannot sit, say, court, please come to my house and take my case. No. Within reason, you see, law is giving you all the facilities. They are giving you everything that we are there, we will support you. But you also have to do something. You have to go to court of law. You have to file the case. Court of law is not having so much of time to come to crores and crores of people and say, okay, we'll take your case, we'll take your. Do you think they have so much of time? Obviously not. Okay, so if there are remedies given for you, but you have to take that remedy within reasonable time. So this point clear? So within reasonable time, go to court of law, file a case saying that I want to cancel the contract, it will be cancelled. Sitting idle without doing anything, then you cannot do anything, you have to accept the contract. For this point clear, everybody? Yes or no? So what is now reasonable time? You must be getting doubt. What is reasonable time? 1 week, 10 days, 15 days, 1 month, 6 months? No, nowhere it is given. In law, what is reasonable time always depends on facts and circumstances of the case. Facts and circumstances of the case. It can be any time. Facts and circumstances of case which is decided by generally court of laws. Okay, law did not specify anything. Say why? Because there are various types of contracts. Say if you enter into contracts for some perishable goods, you just have time for 2 days, 3 days, 10 days. You have entered into contract for some, say, electronic goods which will in some time which will become outdated. So for that the reasonable time will be, say, 1 month, 6 months. You have entered into contract for, say, immovable properties, so it can be long duration, 1 year, 2 years, 1.5 year, likewise. So everything depends on the facts and circumstances of your case. Got this point clear? Yes or no? Anyways, this we'll see in detail also in some other topics. So understood? Everybody? Performance? Okay, rights. Is there any right to the parties in case of void contracts? No. Once the contract becomes void, no rights available to any party, no duty on any party. As I told you before, remember, in a contract there are two parties, both the parties are playing two roles. You have right also, you have duty also, and you will have right also, you'll have duty also. So in this case, law is saying that no party will have any duty or obligation to perform, and they will not have any rights to enjoy also. Why? Because the contract has become void. In case of voidable, is there any right given? Right is given. So simple, right is given only to the aggrieved party. Right is given to aggrieved party to say yes or no, also no. So here right is given only to the aggrieved party. Can the defaulting party do something here? No right is given to defaulting party. Okay. In case of void contracts, no rights to any parties. In case of voidable contract, right is given only to what type of right? Right of making the decision to accept or to cancel the contract. Okay. Now, next difference. Difference between void agreements and illegal agreements. So here void contracts we have seen in the first difference, and now what is that we are seeing here? Void agreements. Why? Because these are those type of agreements, void agreements, which are void ab initio. Before difference which we have seen, those are not void ab initio, void. Starting they were valid, afterwards they became void. But in this difference we are going to see only those types which are void ab initio. Now, what is void agreement? Forbidden by law. Something which is, sorry, not forbidden by law, something which is not enforceable by law. Okay. Why it is not enforceable by law? Because no legal obligation is being made. Very good, very good, very good. One of the essential element is not satisfied. That is the reason it is not enforceable. One of the essential is not satisfied from the very beginning. That is the reason it is void agreement. And illegal agreements are what? Those are forbidden by law, prohibited by law. Now this statement is very, very important. Understand this statement. A void agreement is not necessarily illegal. Illegal is always void. So you can get this, you can get this question also. All illegal agreements are void, but all void agreements are not illegal. Explain. You have to give these differences. Okay. All illegal are void, but all void, are they illegal? No. Why? Because all void, are they forbidden by law? They are just unenforceable. They are just not enforceable. Say for example, if I tell you, I will pay you 10 lakh rupees, you make a dead person alive. I will give you 10 lakh rupees. This person is already dead. You make that person alive. Can you do that? Why you cannot do that? Impossible. So when we entered into contract, was that from the very beginning void? Void ab initio? Who said no? Okay. That means maybe when you entered into contract, maybe you thought that okay, I have that capability to make the dead person alive. Afterwards, you must be thinking, is that no, no? Okay, okay, okay. Hey, black magic maybe. Yes or no? Something. No, right? Okay, no, no. No one can do this. This is something which is impossible. Humanly impossible. Humanly impossible. Yes or no? Okay. So, something which is impossible, is that punishable also? Do you think that those persons who are entering into agreement, they are punished? Is it something which is illegal? No, it is not illegal. Only unenforceable. Unenforceable means what? Court will say we will not support you. You enter into hundreds of contracts like that. You enter into hundreds of contracts. You tell please go and get stars. I will pay you 5 lakh rupees. You enter into all those contracts, but we will not support you. For this point clear, but something which is illegal, what law is saying, you should not enter into those contracts. If you enter into those contracts, you will be punished. You will go behind bars. You will have to pay penalties if you enter into those contracts. For this point clear. So all illegal are void, not enforceable, no support of court. But all void, are they illegal? No, they are not illegal. So now you're going to tell me now which is wider. You understood, right? Wider and narrow. Wider. Think and tell me. Raise your hand. Who knows I want the correct answer. Think and tell me. Void agreements are wider or illegal agreements are wider? Good. Very good. Void agreements are wider. In void only you have again illegal. But in void you have many other type of agreements which are void but not illegal. Any one essential element not satisfied from the very beginning, void agreement. But is it illegal? When it will be illegal? When the consideration and object is not lawful. That only one essential element not satisfied, only then it will be illegal. Otherwise, always it will be only void. Any other essential elements not satisfied, it will be what? Void. Certainty of meaning not there. It will be void agreement. But will it be illegal? No. For this point clear everybody? Yes or no? So from this you can say what? All illegal are void, but all void are not illegal. Okay. So void is always wider and illegal is always narrow. Now I think you understood what is wider and narrow. Yes or no? Okay. Let us come to the difference again. Punishable. You tell me. Punishment. Void agreements, are they punishable? Illegal, are they punishable? They are punishable. Collateral. Tell me now. Void agreements, collateral agreements are always. If there is any void agreement, for that you have entered into. Very good. It is valid. Valid. And for illegal, you have entered into collateral agreement. That is always void. Remember this? Collateral for valid is valid. Collateral for void is also valid. Collateral for illegal is always void. Okay? That is the reason why, because I wanted to come to these differences. That is the reason first I explained you collateral. So now you have understood collateral properly, everybody, yes or no? Okay. So example is given here. And agreement with a minor. Obviously, why agreement with a minor is void? He is not having capacity to enter, no ability to enter into contract, so void. But agreement to murder a person is illegal, that is void as well as punishable. Clear? Oh. Now, last type of contract under based on enforceability. Unenforceable contracts. Unenforceable contracts. Now, unenforceable contracts are those contracts which are having some technical defect in the contract. Which are having some technical defect in the contract. That means all the essential elements are present. Everything is good. It is valid. If we see it is everything is proper, but there is some small technical defect because of which now law is saying that it is unenforceable. Maybe when you enter into contract, there is some spelling mistake, change in name of the parties, change in addresses of the parties, some typing error. These small mistakes which are making it unenforceable by law. Say for example, there were two parties who entered into contract. Akshaya entered into contract with Anu. Both the parties entered into contract. So the contract was to sell land, plot of land. When you sell some immovable property, that is plot of land, always the agreement should be in writing. Then only it is valid. Legal formalities to be complied with. It was in writing also. Everything was proper. All the essential elements were satisfied. But instead of writing Akshaya, this A was missing. They wrote Akshay. Akshay entered into contract with Anu. Because of that, now it is unenforceable. The contract which you entered it on is unenforceable. Now what you have to do for this? You have to rectify the defect. You have to make a new contract, again new agreement in writing where you have to correct the defect. Then only it will become enforceable. The previous contract where you had that defect, that defected contract will be unenforced. Clear with this? Yes or no? Otherwise it is all valid. Because of some technical defect, now it has become what? Unenforceable. Okay, that is only unenforceable. Unenforceable again is what? Something which is having no support of law. Okay. But here what is the difference between this void contract and unenforceable contract? Difference is in void contract, any essential element is not satisfied. Here all essential elements are satisfied, but there is some technical defect only in the contract. Okay. Now, so understood? These are the various type of contract based on validity or enforceability. Now let us see various type of contracts based on formation. Okay, so based on formation, contracts are divided into four types. The first one is what type of contract? Express contract. Express contract is a type of contract which is expressed using words. Whenever there is a contract which is expressed using words, it is considered to be express contract. You can use words either orally or in writing. It can be in writing also or it can be oral also. Then also it is valid. In both the cases, what are you doing? You are making use of some words. Those type of contracts are known as what? Express contracts. Spoken words or written words. You go to a shop, You want to buy a Maggie packet, you go to the shopkeeper and you say, give me one Maggie packet, see, take this money, 10 rupees, 15 rupees, whatever it is. Those type of contracts are what contracts? Express contracts. You are orally entering into the contracts. You're using words in the contract. And written, if you enter into some written contract, say some inmovable property, contracts of insurance, these type of contracts compulsory should be in writing. Okay, any business contract also, say sale of some material, supply of some material, in those cases also there is a compulsion that it should be in writing in some cases. So that contracts also are in writing. You're using words. What words? Written words. That is also considered to be what type of contract? Express contract. Clear? Okay, so this is your express contract. Express contract is a contract which is expressed using words either orally or in writing. Second, implied contracts. Implied contracts are those contracts which are implied by conduct of the party. Conduct is nothing but actions of the party, or you can say behavior of the party. Where to enter into contract, to accept the contract, you are not using word. But what are you doing? You are doing some action. Some you are behaving in some way, or you are doing some, say, nodding of head, showing a thumbs up. All these are considered to be what? Actions. Yes or no? Which is saying that you are saying a yes. You are agreeing to accept the contract. So all these are type of contracts where there is no use of words. Only by your actions you are entering into contracts. Those type of contracts are called what type of contracts? Implied contract. Understood? Say for example, you go to, say, these departmental stores, big stores, Ratnadeep, D-Mart, all those type of stores. So what is there? Generally, if you have any doubt, if you don't find something, you talk to that person. But otherwise, do you go and ask, can I buy this product? Will you sell me this product? No. Everything is displayed. You just go, you take your basket, you go, whatever products you want, you take those products. Do you speak something? No, generally. There is no requirement. You go and take the products, you take that basket to the cashier will see all the products, will scan the products, give you the bill, you'll pay, and the contract is entered. What type of contract? Sale of goods. You have purchased goods and the shopkeeper has sold you goods. But were there any words used here? No, it was only by actions that happened. You went, yeah, acceptance also happened by actions, and your offer also happened by actions only. You offered that I want all these goods. You went and you gave the basket. And the cashier, the DMart person accepted it how? He gave you the bill. Okay, okay, I will sell you these goods. There is offer, there is acceptance by actions, conduct of the parties, behavior of the parties. Therefore, these type of contracts are known as what? Implied contract. Got this point clear? Yes or no? So these are implied contracts. Implied contracts are contracts which are implied by the conduct of the parties, behavior of the parties, actions of the parties. Okay. Now in this implied contract, there is another name for implied contract actually, which is tacit contract. That is the reason I told you that is not another type of contract that comes under your tacit contract. Tacit contracts. The word tacit means silent. To be silent. Silent means what? You are not using any words. You're not speaking. No words are used. Those type of contracts are what contracts? Tacit contracts. Here also, what is this contract? Any contract entered into by the actions or conduct of the parties is known as tacit contract only. So it is nothing but it is another name for your implied contract only. So it is one and the same. Tacit contract, implied contract are actually one and the same. See, if I give you another example for this implied and tacit contract, you want to withdraw some money. Okay, you're going to ATM machine. Going to ATM machine, you're using the card, inserting the card. Are you going and telling machine, please give me 10,000 rupees? Are you speaking or writing anything? No. How? What are you doing? You are performing some action. Because of that action, what is happening? There is a contract which is entered between you and the bank. You are performing some action using that machine, inserting the money, you are, and inserting the card. You are Typing your pin there, you will get the money. Amount you will type there and you will get the money. So everything here, this contract is entered how? The contract is entered only by action. What is happening now? The bank will give you money and it is going to be debited from your account. Understood? Yes or no? So this is also type of what type of contract? Tacit contract, implied contract only. Why? What is used here? Conduct of the parties. Okay? Actions of the parties. Clear with this? Okay. Quasi contract. Quasi contract. The word quasi means just like. Something which is just like a contract, but it is not a contract. It looks like a contract. It is something which is similar to contract. It is similar to contract, but is it a contract? It is not a contract. Quasi contracts are those contracts which are implied not by actions but implied by law, which are forced on you. Implied means forced on you by law. Law is telling you, though you did not enter into any contract with any person, but you have to perform some duty for that person. Say, did you ask? Okay, after class. Any doubts are there? Say, for example, there are two parties, A and B. Okay, A went to B's place to buy some goods, groceries maybe, some groceries, some household things. Okay, and he is the shopkeeper. Where B is the shopkeeper. Now, what did A do? A went to his shop, bought the goods, and A went back to home. But when he was there, what did he do? A left the shop, leaving the bag behind. Whose bag? A's bag. A's bag is now still in the shop. Forgot to take the bag. Without bag only, sorry, B's bag is still in the, sorry, yeah. A's bag is still in the shop. B is the shopkeeper. Okay. A's bag is still in the shop. Okay. Now, here B, as per law, is known as finder of goods. Who is B now as per law? Finder of a lost goods. Any goods which are lost, then B becomes the finder of that goods, that is B, the bag. Okay, bag is lost. Now, can you think law is allowing B, okay, whatever there is, because he has forgot the bag, left the bag, now whatever is there, now it is B's bag only. Whatever things are there in the bag, now it will become B's things. Is that thing which is allowed by law? No. There is some duty that law is imposing on B now. What duty? To safely keep the bag in his custody, in the, to keep the bag in the safe custody of B. That is the duty between A and B now. Now, do you think there was a contract entered between A and B? Did A say, if at all I lose, if at all I forget my bag here, please you safely keep my bag with yourself? Wasn't any contract entered? No. There was no contract entered, but there is a duty like a contract. There is a duty as the duty is there in the contract. Same duty. Who is imposing that duty on B? Law is imposing that duty on B. So these type of contracts are known as what contracts? Quasi contracts. You have many types of quasi contracts which we will see in your unit 6. Sixth unit is all about your quasi contract. I just gave you one example. Likewise, you have other examples also there in unit 6. But did you understand now what is quasi contract? What is a quasi contract? Quasi contract is a contract which is like a contract. There is no offer here. There is no acceptance. Only duty is there. No offer, no acceptance, no consideration, no rights. Only duty on one person to for other person, to be performed for other person. And how is that duty? Duty is as a duty in the contract. You have to do it. You don't have any other choice, but you have to do that duty. Those type of contracts are known as what type of contracts? Quasi contracts. Understood? Yes or no? So here it is the duty or obligation. Duty or obligation of B. What is his duty or obligation? To keep the bag in safe custody. That is his duty. This duty is like a duty in the contract. Therefore, it is now a contract. Here, that is a quasi contract. E contracts. So what are e-contracts? E-contracts are those contracts which are entered electronically. Nowadays there are a lot of e-contracts. Yes or no? Many this Zepto, all those are what type of contracts? You buy goods from Zepto, okay? You purchase goods online. Yes or no? All this Amazon, Flipkart, Mintra, everything is what you purchase and sell. You are going to, okay, there is cash delivery also, but many times what you do, electronically only you are paying the money. Electronically you are entering into contract, electronically only you are paying the money. So those type of contracts are what contracts? You are using electronic means to enter into contracts. Those type of contracts are what contracts? E-contracts. There is electronic data interchange. Electronic data interchange means what? We are exchanging each other's data electronically. You want to sell me some goods. Are you coming to my house and showing those goods? No, electronically you're showing me those goods. I want to search for something. Am I coming to a shop and searching for goods? No, electronically only I am doing it. Electronically your name of the shop is coming to me. Electronically your address is coming. My address is going to you. My name is going to you. How it is happening? Through electronic means. That is known as what? The data of both the parties are being exchanged electronically. That is electronic data interchange. Through electronic data interchange, what are we doing? We are entering into contracts. Terms and conditions are also decided electronically. Understood? Those type of contracts are known as what? E-contract. Okay. So other names for these type of contracts are electronic data interchange contract, that is EDI. EDI का full form क्या है? What is the full form of EDI? Electronic data interchange contracts or cyber contracts. Cyber is nothing but something which is related to your internet. Electronic mediums. Mouse click contract. Mouse click means just you are clicking and the contract is entered. You are clicking yes, contract is entered. Submit, contract is entered. So that is nothing but mouse click contracts. Understood? Yes or no? So these are known as e-contracts. No example. Example only for your understanding I am giving. You don't have to give any example only actually. No examples. If there is any case law, please specify the name of the case law. Case law के facts also you don't have to give. Facts I'll tell you. जैसे कि in I told you what was the case, what happened, but you don't have to write. Nothing you have to. Only the name. Only the name. Only the explanation part of the what is intention to create legal relationship. That means the party should intend to create legal relationship. That you have to give, and only the case law. You don't have to give the facts of the case also. But what happens, uh, in exam there are some type of questions where they are going to give you a case. Okay, they are going to give you one case. Case will be same as a case. Say there it was Balfour versus Balfour. They will say some other name. Mr. A versus say what you say any surname Surana versus Surana. Okay, some other name they are giving. Mr. Surana did this to Mrs. Surana, like that they are going to say. But the case is going to be the same case, Balfour. So you just have to give the case law name. That is Balfour versus Balfour. The case is same as this case, and in that case you will have to give the facts. Facts also how? In your own words. Why? Because case laws are considered to be something which has happened. Some situation has happened there. So those situations you can explain in your own words. You don't have to stick to the comma, whatever is given in the book, same thing. No. That is only for your definitions. Understood? Only in those cases you have to give the case law. You have to, so for that you don't have to by heart the facts also. You just have to remember the facts. Acha, this has happened. Okay? And examples, so whichever I'm giving you, you don't have to write any example only. No example. It is only for your understanding I'm giving you. Okay, in exam only the main part. Okay. In your material also I did not give any examples. Examples you have to write. Either beside the material you write or you write in your notes. That is the reason I did not give. Why? Because if it is given, then there's no work. There's only just sitting in the class, idle, listening, one ear listening, another ear, it will go out. That I didn't want it. So that is the reason what I want the topic, the explanation is there in the material, but examples for your understanding in your own words you write. To just understand the topic. You don't have to write that in your exam also. Okay? Electronic e-contracts are nothing but where you use some electronic means to enter into contracts. Those are your e-contracts. Understood with us everybody till now? Yes or no? So we have completed contracts on the basis of formation. Formation. On the basis of formation, there are contracts. What are the contracts? Express contracts, implied contracts, quasi contracts, e-contracts. Now the third basis. On the basis of performance. On the basis of performance, contracts are divided into executed contracts and executory contracts. Executed, the word executed here means in this case both the parties to the contract performed their promises. Both the parties to the contract has done what? They have performed their promises. Here the contract was formed as well as it was performed. Then finish what I had to give you my car. You had to give me 5 lakh rupees. I gave you my car. You gave me 5 lakh rupees. Done, finish. We have performed the contract. Now, this type of contracts, executed contracts, come to an end. They are discharged. Finished. Nothing is to be done now. Over. Okay. What I have to do, I have done. What you had to do, you have done that. Finish. It is over. It is discharged. The contract has now come to an end. Those type of contracts are known as what contracts? Executed contracts. X went to Y. X wanted to buy some rice, say 5 kg rice. Okay, he is the shopkeeper. So X is coming to Y and telling, I want 5 kgs of rice. So Y saying, okay, take this 5 kgs. He is taking the rice, weighing the rice, giving the rice to X. And what is X doing? X is paying this to whatever is the price that is being paid. Then everything is done in the contract. Is there anything pending in the contract now? The contract was for purchase of rice, paying of price as consideration. That is done. These type of contracts are known as what contracts? Executed contracts. It is performed. Okay. Now you tell me what will be executory? Executory contracts. Contracts which are to be performed in future. Contracts which are not performed but which are to be performed in future. Contracts performed in future are known as what type of contracts? Executory contracts. X entered into contract with Y. Okay. This again. Before seeing this, so contracts which are required to be performed in future are known as executory contracts. Executory contracts are again of two types. Unilateral contracts. Now you tell me what is that you mean by this word uni? Single, one. The name itself is telling you the performance is pending only from one party's side. One party already performed, but one party still have to perform the contracts. Those type of contracts are known as what contracts? Unilateral. So it is a type of executory contract only. Unilateral contract. Okay. So if one party did not perform, both the parties did not perform, it will come under what type of contract? Executory. Both the parties performed, it will come under which type of contract? Executed. For this point clear? Executory contract. Okay. Performance of one party pending. Performance of one party is pending. That type of contract is known as unilateral contract. Okay. Say for example, now here I'll take the same example. Okay. X is, what happened? Okay. X is going to Y shop to buy 5 kgs of rice. Okay. X is required to now pay to shopkeeper the money to buy the rice. Yes or no? So what is X doing? X is already paying 500 rupees to Y. X said, I am giving you 500 rupees, and whenever rice is available with you, I want basmati rice. Basmati rice you send to my house. You know my house, I stay nearby. Already, always, whatever X wants, he takes from Y only. Okay, so he knows the generally delivery is done by Y to X's house. So here, you tell me who has performed the contract? X has performed the contract by paying the price, but still it is pending from whose side? Y's side. This type of contracts are known as what contracts? Unilateral contracts. Performance pending from one party side, those type of contracts are unilateral contracts. Now, after 2 days, what happened? Rice were available. Available, so what did Y do? Y delivered the rice to X. Delivery was done after 2 days. This executory contract after 2 days will become executed contract. For this point clear? Once it is executory, why it is executory? Because performance is pending. Once performance is done, then executory will no longer be executory, it will become executed contracts. Clear with this? Okay. Now the next one, what type of contract? What is that you mean by this term by? By means to. Obviously, that means what? Performance is pending from both the parties' side. Performance of both the parties pending. Performance of both the parties is still pending. Those type of contracts are known as what type of contracts? Bilateral contracts. Now if we take the same example where X wanted some rice from Y, 5 kg rice. Okay. Now X went to Y, ordered, I want 5 kg rice. What did Y say? I don't have, I will order, I will get the rice, I will deliver you in 2 days. So in 2 days, what will happen? Y is going to deliver the rice. X is saying, after 2 days when you will come to deliver, that time only what I will do? I will pay you the price. So the price is also paid when rupees 500. It is also paid in 2 days at the time of delivery. At present, when the contract is formed, it is what type of contract? Bilateral contract. 2 days it will become what? Executed contract. Executed contract. Clear? See, in this case, what happens, now it is bilateral. After 2 days, it can become unilateral. After 5 days, it can become executed again. It depends on the terms of the. Say, if I'm saying that I will deliver you after 2 days, but that person saying that, okay, I don't have cash, I will pay you after 5 days. Then what will happen? It will be bilateral at the time of formation. In 2 days, it will become unilateral, but after 5 days, it will become executed. That can also happen. Yes or no? It all depends on the terms of your contract. What is that you are deciding in the contract? Clear with this? Yes or no? So did you understand this also? So these are the type of contracts based on performance. On performance, contracts are divided into two types: executed and executory. In executory, you again have unilateral contracts and bilateral contracts. Okay. These are various types of contracts under. See, one more thing. In your material, if you see, I have given you a topic contracts under English contracts. Yes or no? It is not there in your syllabus. Material, your institute material is not giving you. But because I gave you, I'll just give you a brief introduction about it, but it is not important. Why? Because see what happens, you should think ICI material is our Bible. Everything given there, from there only everything will be asked. Something which is not given in your ICI material, it will be not asked. Only from there. Why? Because this is your foundation level, starting level. So they will test you only on the things given in the material. Intermediate level also very less. Final level maybe they'll test you common things also, so that they'll test whether you have general knowledge also about general knowledge, not about what is going on in the country. General knowledge about the subjects of CA, taxation, audit, accountancy, law. In all these cases, generally also they may ask. But in your foundation level, intermediate level, only they will stick to the syllabus. Nothing apart from syllabus they'll ask. This was actually included in your CPT when you had CPT, no? This topic was included. Contracts under English, was the types of contracts under English law. Now it is removed, not there in your syllabus. But because it is given in the material, I'll just give you a brief introduction of what it is. Okay, that you should know that. Types of contracts under English law, not your Indian law, English law. Okay, types of contracts, which is not something which is there in our country, but which is there in other countries. Okay, so type of contracts under English law. The contracts are divided into two types here. First one is formal contracts, and another one is simple contracts. So they are divided into two types. What are the two types? Formal contracts, only this is the classification, nothing else. Okay, formal contracts and simple contracts. Under formal contracts, you again have two types: contract of record, contract under seal. Contract of record, contract under seal. Seal. Okay. Now, under contract of records, again you have two types: judgment of court, recognizance. Judgment of court and recognizance. Don't worry, not important. If you understand, well and good. Don't understand, leave it. Okay? Why? Because not anyway, it will not be asked. Why? Because it is there. You should know extra knowledge I'm giving you. Otherwise, not important. Okay? See, contract of record. Contract of record are of two types: judgment of court and recognizance. What is this judgment of court? See, judgment of court is nothing but there is a contract between two parties, not because they have entered into contract. Why? Because there is a judgment of court. Court is telling, now you did this wrong with this person. Now every month you have to pay this person 5,000 rupees. Why now I will have to pay you 5,000 rupees? Why? Because there was a judgment of court. Court ordered me to do this. Now is there any duty on me? Yes, I will have to pay you every month 5,000 rupees. That is my obligation. But why is that obligation on me? Only because court said that. Judgment of court. There was a judgment. There was a decision of court. There is no offer, no acceptance, nothing. But there is a relationship between two parties. How that relationship came into existence? Because of the judgment of court. Otherwise, there was no relationship. Those type of contracts are known as what? Judgment of court contract. It will come under judgment of court. There is a contract. Why? Because of judgment of court. Anything can happen. Say, you have sold um, some defective goods to a party. Lot of defective goods you have sold. All the goods were defective, because of which his reputation went wrong, and there are no customers coming to his shop now. But that happened because of you. Yes or no? Now court will order, as a penalty, every month you have to pay for 5 years. 5 years, every month you have to pay this person this much money, because of you he is bearing so much of losses. Now for 5 years, is there any contract between both the parties? What type of contract is there? What type of contract? Every month you have to pay 5,000 rupees for 5 years. Yes or no? That is that contract, that obligation, that duty is there. Why? Because of judgment of court. Clear with this? That is the judgment of court part. Recognizance. Recognizance is only between the law and a party. There is no other party involved. Always there will be court of law and one party. Say for example, you are not paying taxes. 1 year, 2 year, 3 year, 5 years you did not pay taxes. Now those will become due on you. Now you will have to pay the taxes along with the penalty. So because now the law will order you that you have to pay us the taxes as well as the penalty. So there is a contract between the party and the law. For this court, law say, not the court actually, law. Any sales tax officer, income tax officer, those people you have to pay. Okay, law. Those people are the law. Okay, they are going to, they are having the supervision, everything to take care of their whatever is there in their field, under their field. They have to take care of that. Okay, so in that case, what happens? There is a contract between the authority and a person, normal person. Those type of contracts are known as what? Recognizance. Understood this point? What is judgment of court and recognizance? Got the difference? In judgment of court, there is judgment of court between two normal parties. But in case of this recognizance, law and a normal party. Clear with this? Yes or no? So that comes under your contract of record, judgment of court and recognizance. Contract under seal. In any contracts, there are some formalities required. Those all will come under what? Contract under seal. It should be in writing. It should be signed by the parties. It should be stamped by the proper authority. It should be stamped or sealed by the proper authority. Then all these things, all these type of contracts will come under what? Your contract under seal. Any formality required to be complied with in any contract, those all will come under what type of contracts? Contract under seal. Understood with this, everybody? Yes or no? So this is the division of the contract. Contract of record, contract under seal. Now anything which is not coming under all these type of contracts, remaining everything will come under your simple contract. Remaining anything which is not coming under contract of record, contract under seal, remaining everything will be what type of contracts? Simple contract. Clear with this? Yes or no? So this is only the classification given under your English law. I just hope briefly you have understood it. That much is enough. If you have not understood, it is okay. Enough, that is also enough. Okay? No worries. Okay. So that was regarding your types of contracts. Understood what is the discussion going on? Please, we also want to be a part of your discussion. Yes or no, everybody? Yes. What is the discussion? Concentrate. Okay, concentrate in the class. Okay. Now, you tell me, when we discussed essentials of valid contract, in that, did we discuss under section 10 one point that was offer and acceptance? There should be offer, there should be acceptance. There, did I tell you that offer should be what type of offer? Proper offer, valid offer. For that proper offer, valid offer, what are given? Essential elements of offer is also given. If those essential elements are present, then only it will be proper offer, otherwise no. So now we are going to start the topic of offer. We know what is offer. Yes or no? We know what is offer. But now here we are going to see that in detail. You tell me offer is defined in what section? Very good. Clause A of section 2. As per clause A of section 2, who is going to give me the definition? He is said to make a proposal. So another word for offer is nothing but proposal also. Both are synonymous. Synonymous means used interchangeably. It can be used interchangeably. Offer is proposal, proposal is offer. Both are one and the same. So that is defined in your section, clause A of section 2. Now here, when one person signifies to another. So you tell me, how many parties are there? Two parties. One person who is signifying, this person is known as offerer. This person is known as what? Offerer. To another, when you are signifying, you are communicating to this other person. This, yes, acceptor, or see, generally what happens when offer is made, it is better that before saying acceptor, we say he is the offeree. Offeree. Why? Because did he accept till now? Did he accept? No. There is a proposal, there is an offerer, but he did not become the acceptor till now. He is just an offeree. A person to whom offer is made is offeree. The person who is making the offer is the offerer. Once this person says a yes, he will no longer be offeree, he will become acceptor. When he will become acceptor? When he is saying that yes. Understood? Yes or no? Okay. So when one person signifies to another, that is the person who is giving the offer is offerer. The person to whom offer is given is known as always the offeree. Okay. When one person signifies to another his willingness is what here now? Wish. Whatever he wants to do, his wish to do or abstain from doing. To do or abstain from doing, I told you before also. To do is positive, to abstain from doing is negative. That is to stop oneself from doing something for another person. Okay, to do or abstain from doing anything with the view to obtain the assent. I want the other person to always say a yes, assent of that other. Then he is said to such act or absence, then he is said to make a proposal. So you are clear with the definition? Yes or no, everybody? Okay. Now before going to essential elements of offer, first we are going to see types of offer. What is that we are going to see? Various types of offer. Types of offer. There are many types of offer, okay, but just for few types of offer there is a classification. Say how it is made. If you want to see how that offer is made, for that it is divided into two types: express offer, and another type is implied offer. To whom it is made, if you want to see, then it is two types again: general offer and specific offer. How it is made, two types: express offer and implied offer. To whom it is made, again of two types: general offer and specific offer. Say, you only tell me now what is express offer. Any offer expressed in words, express offer. Any offer expressed by actions, implied offer. Understood what it is? Same thing as we have seen in contract, but this is only for offer. Contract is not entered. Just I am expressing my willingness, my wish in words. I am telling I want to do this for you. I want to sell you car. I want to sell you 100 bags of wheat. Whatever it is, I am saying that in words, either oral or written. Then it is going to be what? It is going to be always express offer. Expressed in words, orally, or in writing. Okay, those type of offers are considered to be always actions or conduct of the parties. These type of offers are always known as what offers? Implied offers. Clear with this? Yes or no? This is very simple. Now let us come to general offer. General offer, to whom it is made. On what basis it depends whether it is general or it is specific, to whom it is made. The first one we are going to see is general offer. General offer when it is made to public at large. When it is made to whom? Sorry. Public at large, it is known as what type of offer? General offer. That means from general public, anyone can accept it. Anyone can accept your offer, then those type of offers are known as what offer? General offers. There is a case law because of which this general offer came into existence. That case law is what? Carlyle versus Carbolic Smoke Ball and Company. Okay, Carlyle versus Carbolic Smoke Ball and Company. Now just I'll tell you the facts of the case. What happened here? There was a company, Carbolic Smoke Ball and Company. When this case law came into existence, that point of time, there was rapid spreading of influenza, a type of flu, a type of disease, flu. Rapid spreading was happening. So this company, Carbolic Smoke Ball and Company, came up with these type of smoke balls, and they claimed that anybody who consumes these smoke balls will not get influenza. Anybody who consumes this smoke ball as per our directions, there are directions which are given. So as per our directions, who consume the smoke balls, what will happen? They will not get influenza. There was a lady, Carlyle. What did she do? She, as per the direction, consumed the smoke balls. After consuming the smoke balls, also, what did she get? She got influenza. And this company claimed, saying that if you get influenza after consuming our smoke balls, then we will give you prize money. Sorry, not prize money, compensation. Say, we will give you 100 pounds. We will give you 100 pounds if you consume. After consumption also you get influenza, then the person who gets that influenza, how much we will give you? 100 pounds we will give you. Now this lady Carlyle, she consumed as per the directions. After that also what happened? She got influenza. Then she recovered from influenza afterwards, taking some other medicines. Now, what did this lady do? She went to court of law. She went to court of law and filed the case against whom? Against this company, Carbolic Smoke Ball and Company. Against this company, what did she do? She filed a case saying that now they will have to pay me compensation of £100. But what did this company say? We did not give any offer. We never went to Carlyle and we never went to her and said that please consume smoke balls, and if you consume and you get influenza, we will pay you this much money. So company, what was the uh, defense made by this company? They said that we never made any offer. But in this case, court gave the decision in the favor of this lady Carlyle. In this case, court said that whatever offer was made by this company, Smokeball and Company, was what type of offer? General offer. Because it was a general offer, then it could have been accepted by any person in public. Any person in public in that country, in that wherever the advertisement was made, any person could have accepted it. It was not made to any one person, it was made to public at large. Why? Because in the advertisement they never said any group of people or any specific person. They said whoever consumes, after consumption they get influenza, we will give you how much? £100. So this type of contract offers are what type of offers? General offers which are made to public at large, which can be accepted by any person from the public. Any person can accept it. It will become a binding contract. It will become a binding contract. Any person accepts it, it will become what? It will become a binding contract. Got this point clear? Understood what is this general offer? See, this general offer was not there before this case law. Only after this case law came, after that also they introduced this new type of offer, general offer. Okay, there is an offer which is general offer, which is to be now a type of offer which can be accepted by any person from public. Clear with this? General offer, everybody? Yes or no? Now, second type of offer is what? Specific offer, or you can say special offer also. Special offer or specific offer. Now you tell me what will be this specific offer. Name itself is telling you. Particular person or particular group of people. When the offer is made to specific person or it is made to specific group of people, it is known as specific offer. Specific person or specific group of people, then only it is specific offer. A is entering into contract with B. I want to sell you my truck. I will sell you my truck. You pay me 50,000 rupees for my truck. Now, this contract, when A and B were entering into contract, there was a person C. You know, there are some people who is having habit of listening to other people's whatever they are speaking. So he happened to hear to whatever A and B said. Now B is going to A and telling that I will purchase your truck. Is there any binding contract between A and C now? No. Why? Because this contract was made only to a specific person, that is only B. So who should give the acceptance? The acceptance can be given only by B to A. Then only there will be a binding contract. If A wants to sell it to C, then he should offer it to C also. He can offer it to C. C will say yes, there will be a contract. But this offer was made to only specific person B. Who can give the acceptance here? Only B. Clear with this? This type of offers are known as what offers? Say for example, there is a person X who is a chartered accountant. So he is having a office of a chartered accountant. All the furniture, everything is as per a chartered accountancy office. Now he is making an offer, advertisement he is giving, where he is saying that I want to sell my office to any of the chartered accountant. Any chartered accountant can buy the office. This is specific or general. Why? It is given to only a specific group of people. not to public at large. Only when it is given to public at large, where anybody, old, young, children, CA, doctors, anybody can accept those kind of offers. Those type of offers are known as what offers? General offers, which can be accepted only by specific person or specific group of people. Those type of offers are known as what offers? Specific offers. Clear with this? Everybody, there is a case law for this also. Just we'll discuss the case law. Bolton versus Jones. Bolton versus Jones. See, generally I'm just telling you this for your information. This first party, whenever there's a case law given, first party is the plaintiff. This party is known as what? Plaintiff. Plaintiff is who? The person who files the complaints. The person who is filing the complaint is known as the plaintiff. The other person, the second person who is written second, that person is always known as defendant. Who is defendant now? Who is going to defend the case? I have a problem with you. I am going to court of law and I am filing a case against you. I am plaintiff. Now you will say to court of law, no, I did not do this. I am not at fault. Defense, if you say something in your defense, then you're known as what? Defendant. Got this point clear? Just for your information, I'm telling you. Okay, so plaintiff and defendant are two parties in the contract. Now, what happened in this case? There was this party Jones. Jones always used to, what do you say, give orders to a person known as Brockley Hurst. Hurst was a person to whom always Jones used to enter into contract for supply of material. Who used to supply material? Brocklehurst used to supply material for the business of Jones. Jones had some building business, okay, construction business. For that construction business, who used to supply the material? Brocklehurst. Okay, so now what happened? Brocklehurst sold his business to Bolton. What did he do? Sold his business to Bolton. Jones and Brocklehurst were in this relationship, business relationship, for many years. For many years, they were into this business. Okay, this business relationship that always Brocklehurst used to supply, and the Jones used to use the material for building. Okay, now what happened? Brocklehurst sold the business to Bolton. Jones did not know about this sailing of business. He did not know. He's still thinking that who is the owner of the business? Brocklehurst. And he gave the order to Bolton, thinking that Bolton is Brocklehurst only. And what did Bolton do? Anyways, he was not getting order. It was new business. Okay, now I got the order. Now I will fulfill the order and get the money. So without saying anything, what that letter, Jones gave a letter saying that, hi Brocklehurst, everything was in the name of Brocklehurst. But who fulfilled the order here? Bolton fulfilled the order. Here the offer was made to whom? Who should say a yes to that order? But who did that? Bolton. Bolton supplied the material. After supplying the material, when the time came to pay the money, pay the bill, Jones had to pay the bill. He saw the bills were in the name of Bolton. What did he see? The bills were in the name of now Bolton. He went and said, Bolton, I don't want to enter into contract with you. I thought you are Brocklehurst. That is the reason I gave you the offer. In that case, Bolton said that I already supplied you the material. You have to pay me the money. Here Jones is saying, you take your material back. I will not pay you anything. You take your material back. Why? Because I don't want to enter into contract with you. Bolton went to court of law. As I told you, he's plaintiff. He's the person who is going to file the complaint. He went to court of law, filed a complaint saying that I entered into contract, I supplied the material. Now he's saying that he will not pay me the price. In this case, you tell me in whose favor court will give the Jones favor. Okay, why? Because this type of offer is what offer? Specific offer, which is to be accepted only by that specific person. For this point clear? So this was the case law for supporting your specific offer. Whenever there is specific offer, it is to be only accepted by the specific person or that specific group of people and no one other than that person. Offerer can always cancel the offer, take the offer back if other person is accepted. As it is given in this case law, Bolton versus Jones. Clear with this, everybody? Yes or no? Okay. So for today, let us stop here. I just hope you have understood everything. I want everybody to go home and revise. Law is something which you tend to forget. Very easily you will forget. When you study, it will be very interesting. You will understand everything. But this is, I am telling you, I have that experience. You will forget it very soon. And here all the topics are interrelated to each other. If you don't remember previous topics, you will not understand the new topic also. Better go home, it will take just 15-20 minutes. Maybe you'll think we are tired, we cannot do. Sleeping, just relaxing, you can read. Yes or no? Relax. I understand. I also went through your stage. I was also a student. I know how it is, but I know this is important. That is the reason I'm telling you. You should not face some difficulties in future. Please revise. Everybody, every day revise. It'll take hardly 15 minutes. Okay. Okay.